Okay, we're back. We're going to talk about chapter 6, due diligence. Due diligence is something that is required in a lot of areas of law, but we're going to specifically talk about it when you are acquiring land. Okay, so if you are a purchaser of land, you want to make sure that you are doing your research to make sure that you're not going to impose environmental liability by purchasing this land. So, careful inquiry or procedures. This is like the Black's Law Dictionary definition, to secure protection from liability. So, as an attorney or as a legal professional, right, before we are selling a property, we might want to do some due diligence to make sure we're not selling, a total uh, terrible property, right? Do some kind of a little bit of inspection because that'll help us sell it if we cure things before we put it on the market, right? So, like, you're painting your house, or if you have mold, you do something to repair the mold. Otherwise, if someone finds it later, you're going to have to fix that anyway. Okay, so that's just kind of in your best interest. But really, before buying a property, you're going to, on your own side, make sure that you're not, buying a dud. Um, and then, yeah, before making a statement about a property you're selling, no, there's no lead paint, right? Like, so you avoid fraud charges later. So due diligence, we're really dealing with this in a commercial real estate sense in this chapter. But as we were talking about last chapter just a few minutes ago, that in residential real estate, you do home inspections to make sure you're not getting something with radon issues or mold. Those are kind of the environmental issues, or leaks, or all of that stuff. So CERCLA is a statute that we're going to talk about later on in the semester. Comprehensive Environmental Response, Compensation and Liability Act. It's they also call it Superfund. So what it really says is, if there's a piece of land that you owned that there is toxic or chemical, you need environmental cleanup of the site, um, you are liable if you were anywhere in that chain of property, in the chain of title. Okay, so even if they didn't contribute to the pollution, if you kind of owned it for a while, you can be held liable under CERCLA. Um, so, and it's retroactive. So even if you polluted before 1980, you can still be held responsible. They also, another word for CERCLA, it created what we call the Superfund, which is a fund created by our government that allows for like a quick cleanup of a site um, before they know who they're going to then recover some of that money from. So it's a way of like really making people think before they pollute. So the people who have to pay or potentially have to pay under CERCLA are called potentially responsible parties, PRPs. Okay, so those are the people who are possibly, or entities that are possibly liable for contamination. So your current owner and operator is always a PRP. Any owner or operator who was there at any time there was disposal or use of hazardous substances, anyone who arranged for the disposal or treatment of these hazardous, you know, substances, getting it off the site, or treatment of the hazardous substance, and anyone who accepted. So, like, maybe where it originated and it end up on the site, you're going to be responsible. And then anyone who accepted that for this site, and they selected that site the for the disposal of the waste. Okay, so things, it's kind of sucks to be a potentially responsible party in a CERCLA cleanup because they're very expensive. So there are some types of PRPs who have some defenses. So if I am what we call a secured creditor, so I'm a bank and I had held a mortgage on a property and I foreclosed on the property, and I own the property then because I foreclosed on the property and then I was trying to sell it. So you are what we call a secured creditor. and you are not, that is a defense to liability under CERCLA. So you may or may not be, you may not be a PRP. However, there's some cases that said if you did some, you managed the land then, and you had arranged for, I don't know, maintenance of it or guarding of it or whatever, you did some management of that land, you may be held liable as a PRP. Fiduciary, so say this was in trust and you're like a trustee and you're selling the land on behalf of others. It's not your land. You never had any ownership in the right in the land itself. That's a defense to being a potentially responsible party. Innocent landowner. So if I just like I'm next to this big old chemical plant and maybe some of the stuff seeped onto my land without me doing anything, innocent landowner is a defense in CERCLA. What we call the bona fide prospective purchaser. So you're buying the property and you did some research to see what happened, to make sure that you're buying clean land, and it looked pretty good for you. You can use that, and you never polluted after that, and everything happened before you acquired the property. You are that's a defense. Uh, So that was after January 2002. A landowner may purchase property with some knowledge of contamination and be protected, if they kind of have that same innocent landowner or contiguous property owner, like same thing, right? Somebody else next to you polluted. You just have to prove that all the bad stuff happened before you owned it. Now there's like this Brownsfield program. So these are kind of people who are trying to conduct response actions at these like certain sites, these Brownsfield sites, which are kind of state cleanup programs. So like anything that with real or perceived contamination. So if you're acquiring the site for the intent of cleaning it up under some state programs, then you're not going to be liable under CERCLA. So if you're interested for specific actions under CERCLA or the who is liable on page 131 of the text going on, right, which has our exceptions, contiguous properties, bona fide purchasers, all that good stuff. You can take a look at that there. It'll be a little boring for me to read that out to you, but I would recommend that you look at it yourself. Okay, so as a legal professional, what you want to do, oh yeah, there's your Brownsfield sites, very broad. So all of your defenses, there is this common, some sort of lack of fault if you're trying to defend yourself from CERCLA, right? I didn't do anything. I didn't pollute. I am currently cooperating with the cleanup efforts or the inspection efforts. I'm not. I'm working my best to avoid any future release of toxic waste. This is a big thing. Before I acquired the property, I have done what we call all appropriate inquiries. This is a big term in the due diligence, AAI. So remember that one. So they're trying to figure out what I can do before I buy this to make sure that there is no any contamination. Now, one of the things you might also do is if you're thinking about buying a site, you might apply to the regional EPA office for what we call a comfort letter. So to make sure that the EPA has no knowledge of any contamination about this site. So kind of what the EPA status is. And, you get some comfort by doing that. So, okay, other things that we might want to do as our terms of our lease if we're purchasing something, make sure that the offer of sale is contingent on some sort of environmental assessment. Give yourself adequate time to conduct it. In that contract, you determine what party orders it and pays for it and chooses the company who is performing the assessment. What happens if there is contamination? Are you able to terminate it? Maybe there's terms of confidentiality that you give as a purchaser that you're not going to tell everybody, what your thing came up with, whatever that is. So, if you are performing one of these assessments, the first kind of level of it, that's for sales, leases. If you are a landlord, maybe you have a warranty that the property has no toxic waste, and then the tenant might have to promise not to store or use toxic materials. If there is any event, who is responsible for remediation and what constitutes remediation removal. If there's fines and penalties, who's responsible for that? Is it the landlord or is it the tenant? And maybe, requiring either the landlord or a tenant to issue a bond or buy insurance to cover potential financial liabilities. So those are all things that need to, if you're leasing or purchasing a commercial property, things that you want to think about vis-a-vis environmental contamination. Okay, so if we're like, okay, we want an environmental assessment of a property that our client wants to buy. The first thing that you're going to do is what we call a transaction screen, right? Like a phase one assessment. So it's, what are you going to do to make sure that this property that you're purchasing is not contaminated with any bad stuff? Okay, so you're just buying a property. You don't have a suspicion that there's any contamination. So you do a site visit. You look at the governmental records, like the title records. Maybe look at the activities of people who have owned it in the past. You might conduct interviews of prior employees or prior workers at the site. Look at that historic use. Is there any red flags? You don't really do soil sampling at this point. You're just kind of using the facts to determine if you have to do something after that. You can have an outside consulting firm, usually it'd be an outside consulting firm conducting this, and you have to make sure you kind of choose a reputable one. There are EPA recommendations for the level of experience for one of these environmental professionals to have, and use this as your appropriate, any appropriate inquiries. You're going to use this as your appropriate inquiry standard to become a bona fide purchaser, which would be a defense to CERCLA. But so then what if nothing pops up? You're pretty good as doing any appropriate inquiry. But if something pops up, you're like, oh, I don't know what happened in like the 80s here. That seems like there's something weird. We might need to go to a phase 2 assessment. Okay. If you're trying to look for standards for how to approach things, you can go to this website for the American Society for Testing of Materials. They have uniform standards for commercial transactions. So if you kind of follow those, you're usually in your realm of reasonable care. Okay, so the phase 2, so you're like, oh, something looks a little squirrely here. So you might then again retain an engineering company, to analyze the soil, groundwater, subsurface oil, take soil samples and water samples to see if there's anything fishy in there. They focus on what happened in phase 1. It looks like in this particular area of the property, you know, what happened. Oh, and then just to tell you too, go when you on your own time, kind of look on page 137, 138, just kind of some steps that a someone would do in a phase 1 assessment. Okay, so from this, you're just kind of like either confirming or excluding the possibility of contamination. Like, you know what? We checked all the groundwater, we checked all the soil. We don't see anything. Looks good. If it confirms that there is contamination, then you go on to a phase 3 assessment, which you're not just determining whether there is contamination, but the level of it. And at this point, you might, for your due diligence, you're like, let's move on to a different property. This is not really what I want. Page 139 of the textbooks talks about, what you need to look for specifically when you're examining these environmental assessment reports. The purpose, the dates, the standards. Is there any exculpatory language? There's a bunch of stuff there. Did they meet with ASTM standards? All of that good stuff. So, outside of all the stuff like the private obligations, maybe a property owner has, businesses also have like obligations under the environmental statutes, either state or federal or both, to report leaks, contaminations to state and local authorities under, say, clean air, clean water, or one of the toxic waste statutes. So businesses will have their own processes, their own programs, to make sure that they are complying with the law, right? Because if they don't comply with the law, bad things can happen. They can be fined. There can be held criminally liable. There could be an injunction that they have to cease doing what they're doing. So they want to make sure they're complying with the law. They want to make sure if there is any liability, it's the smallest amount, and they're proving that they are acting with utmost care. And they want, you want to have a reputation as being a good or a green company for your neighbors and for the shareholders. So that's that's why businesses all have their own environmental compliance program. Some states have what we call an audit privilege. So if you are voluntarily like auditing your processes or checking your land and something comes up and, it has to be remediated, it's kind of like if you find it yourself, you're going to be free from other liabilities, fines and things like that, because you've gone over and above and found this rather than making the state or the the feds find that. And EPA's just general policy encourages, internal environmental audits like as voluntary stuff. They also have These statutes also have reporting requirements to the EPA or the local environmental board. So, you have to keep records, maybe submit reports, and you have, document retention requirements for keeping records for a certain amount of time. And the EPA under these statutes have like the right to inspect the property, look at your records, and make sure that nothing fishy is going on. So if the EPA wants to do it, they have a right to do it, but they would maybe have to get a warrant or a subpoena to search your property. In practice, companies do this without, they're like, they want to appear in cooperation, right? So they do this without making the EPA go through those hoops. And that works out for them because then they know that this site visit's going to happen and you can be prepared, right? So you have some sort of checklist ready. You got to call your attorneys, senior officials. You have to make sure that they have someone to give them a tour. You have to pull out all the documents that they need to see. And, if you're working with clients on this, you have to make sure the employees know, make sure they're they know to be truthful and forthcoming. You might have kind of an itinerary or an agenda for where they're going to be when. And whoever their escort is, should have some knowledge. So that's kind of like the best way of doing it, voluntarily. Um, if things may be really bad, there might be a surprise visit with a warrant, and then maybe you're in trouble because they know something, and that's how they got their warrant. And there's also statutes that I don't know if you guys have heard about whistleblowers. So that's usually somebody on the job who tells any authority about something bad going on in that company. So an environmental whistleblower would be an employee who reports some sort of concerns about environmental violations. OSHA, that's the Occupational Safety and Health Administration, federal job safety agency. Their whistleblower provision, that's kind of their world, their purview. So the whistleblower protections are if you report bad doings by the company, your job is protected. Okay, so if somebody contacts the EPA about a violation and then they're fired, that's prohibited by these whistleblower protections on OSHA. So blacklisting, right? So like you don't get promoted, demotion, getting fired, somehow disciplinary actions, harassment, suspension. So you should not be able to be treated like a pariah because you told the feds about environmental violations. Okay, so that is our week 3. Now the next thing is, if you've completed all those other items, you want to go complete the review questions mentioned, in the assignment there. And you have the quiz, you have the discussion board, and you have those other review questions. And that's it. So, reach out if you have questions. Thanks to all of you who have pointed out when I have made errors so I can fix them. I do appreciate it. And have a great week. I'll chat with you next week. Bye.